So get this. A woman is suing for a back injury, claiming that she can't lift anything heavier than 10 pounds. Her lawyer pulls up her Instagram, and there she is 2 weeks ago deadlifting at the gym. The case gets thrown out immediately. Someone files for workers' comp saying they're completely disabled and can't work. Their Facebook shows them at a ski resort. Case dismissed. A personal injury plaintiff says the car accident left them bedridden and unable to enjoy life. Their TikTok shows them at Coachella, dancing in the crowd, living their best life. I'm Jasmine Weg, and today we're talking about something that should genuinely scare you. Everything you post online can and will be used against you in a court of law. Your Instagram stories, your Facebook check ins, your TikTok videos, that photo you thought you deleted still exists. And it's not just criminals getting caught, it's regular people losing lawsuits, custody battles, and disability claims because they couldn't stop posting. Let's get into it. Welcome back to Exhibit A-List, where pop culture gets cross-examined. Quick reminder, find me on Instagram at Jasmine Weg ESQ, follow the podcast Exhibit A-List Pod, and I'm on TikTok at Jazz the Lawyer. Here's what I think most people don't understand. Social media isn't just public in the abstract, anyone can see it sense. It's public in the legal, this can be used as evidence against you in court sense. And the gap between those two understandings is costing people massive amounts of money. Insurance companies have entire departments dedicated to scrolling through claimants' social media. Divorce lawyers check Instagram before they even file paperwork. Prosecutors search Facebook for evidence. Your digital footprint isn't just embarrassing, it's admissible. So today we're going to go through the ways that social media destroys legal cases, starting with the one that happens most often, personal injury and disability claims. So if you're suing someone for personal injury, like a car accident, a slip and fall, a workplace injury, whatever, the absolute first thing your lawyer should tell you is to stop posting on social media immediately. Make everything private. Better yet, just don't post at all, because insurance companies are watching and they are very, very good at finding posts that contradict your injury claims. I know I immediately, when I'm doing a defense case, and go to their Facebook, go to their Instagram, depending on their age, go to their TikTok, go to their LinkedIn and see what they're really doing. The I can't work photos from vacation, this happens constantly. Someone files a workers' compensation claim that's saying that they're disabled and unable to work. The injury is so severe, they can't sit at a desk, they can't lift anything, they can't perform their basic job functions. Then the insurance company's investigator pulls up Facebook and finds vacation photos. The claimant is hiking, jet skiing, carrying luggage through an airport. Now, is it possible to be injured and still go on vacation? Of course. But when you're claiming total disability and your Instagram shows you're parasailing in Mexico, that is a problem. Courts have thrown out claims based on social media evidence showing activities inconsistent with the alleged injuries. And it's not just about proving that you lied, it's about credibility. Once a judge or jury sees you contradicting your own claims, they stop believing anything that you say. There was a widely reported case where someone sued claiming a car accident caused severe back and neck injuries that prevented them from exercising or doing any physical activity. The defense attorney found their gym's Instagram account. The gym had posted a photo tagging the plaintiff in a CrossFit class after the accident. The plaintiff tried to argue that it was a different person with the same name, except they were clearly visible in the photo, wearing a shirt with their own business logo on it. The case settled for way less than it would have because the plaintiff's credibility was destroyed. Personal injury damages often include compensation for loss of enjoyment of life. So like say you used to love hiking, but now you can't because of your injuries. You used to play with your kids, but now you're in too much pain. Those are real compensable damages. But you better not be posting photos that suggest otherwise. If you're claiming you can't enjoy activities anymore and your social media shows you at concerts, sporting events, parties, traveling, defense lawyers will argue that you're not actually suffering the losses you claim. It doesn't matter if you were in pain the whole time. It doesn't matter if you paid for it with 3 days in bed afterward. What matters is the optics. And the optics are you're out having fun while you're claiming that you can't have fun. Slip and fall cases are already hard to win because defendants always argue that you're exaggerating or faking your injuries. Social media makes that argument much easier. Someone claims that they fell in a store, injured their knee, and now they have permanent mobility issues. They're suing for medical bills, lost wages, pain, and suffering. The store's lawyers check Facebook. There's a video of the plaintiff dancing at a wedding 3 weeks post injury. The case falls apart. Could they have been in pain while dancing? Maybe, but juries don't see it that way. They see someone who claims they can barely walk while posting videos of themselves moving just fine. And here's why insurance companies love social media. Because what people don't realize is that insurance companies budget for social media investigations. It's standard practice now. When you file a claim, they're not just reviewing your medical records. They're searching your name on Facebook, Instagram, TikTok, LinkedIn. They're looking at your friends and family's accounts to see if you're tagged in anything. They hire investigators who do nothing but scroll through social media looking for evidence that claimants are lying or exaggerating. And it works. Studies show that insurance companies successfully use social media evidence to reduce or deny claims in a significant percentage of cases. And here's the privacy settings trap. People think that making their accounts private protects them, but it doesn't necessarily. If you're a plaintiff in a lawsuit, defense can request access to your social media during discovery. You have to provide it. If you refuse, the judge can compel you to turn it over or even dismiss your case. And if you delete posts after the lawsuit is filed, that's considered spoliation of evidence. Courts can sanction you for it. In some cases, judges have instructed juries to assume that deleted content was harmful to your case. Making your account private helps with random people snooping, but it doesn't protect you from legal discovery. And so here's what you should actually do. If you're involved in any kind of injury claim, stop posting. Seriously, just stop. No updates, no photos, no check ins, nothing. Don't let friends or family tag you in posts. Tell them explicitly, do not post photos of me, do not tag me, do not mention me. Assume everything you've already posted will be found. Go through your entire post history and look for anything that could be used against you. Better yet, have your lawyer do it so they know it's coming. And understand that even innocent can be twisted. A photo of you smiling at a family dinner can be used to argue that you're not experiencing emotional distress. A check in at a coffee shop can be used to argue that you're not as isolated or depressed as you claim. The safest move is complete silence until your case is resolved, though I know that that's difficult. All right, so that's personal injury, but let's talk about another area where social media destroys cases: divorce and custody battles. Divorce lawyers will tell you social media is their best friend. It's where people reveal the truth about their finances, their lifestyle, their priorities, and their character. And people make it so easy. The I'm broke vacation photos, this is probably the most common one. Someone claims in divorce proceedings that they don't have money. They can't afford spousal support. They can barely scrape by. Meanwhile, their Instagram shows them on a beach in the Maldives, shopping at Gucci, eating at Nobu. Defense attorneys print every single post. They bring them to court and they ask, you claim you can't afford $2,000 a month in support, but you just spent $10,000 on a vacation. Courts are not sympathetic. If you're posting a luxury lifestyle while crying poverty in court, the judge assumes that you are hiding assets or income. Custody battles also often come down to who's the more responsible, involved parent. Social media can destroy that narrative quickly. If you're arguing that you should have primary custody because you're always there for the kids, your social media better reflect that. If it shows you out at bars multiple nights a week, traveling constantly, prioritizing social life over parenting, it could become evidence that you're not focused on the kids as you claim. That might not be true, probably isn't true, but obviously the other side is looking for ways to misconstrue what you post in the way most negative toward you. So think that way and be mindful how someone who doesn't like you or is not on your side is viewing the things that you post. One thing family law attorneys always warn their clients about is photos with alcohol. Even if you're just having a glass of wine at dinner, a photo of you drinking can be weaponized in custody disputes to suggest that you have substance abuse issues or poor judgment. Is one photo of you with a drink proof of anything? We both know the answer is no, but in contested custody cases, lawyers can use every piece of ammunition that they can find. And here's another tricky one. If you're getting divorced and you started dating someone new, posting about that relationship can backfire in multiple ways. First, it can affect your spousal support. In some states, if you're cohabiting with a new partner, then that can reduce or eliminate spousal support obligations. Second, it can be used to argue infidelity or that the marriage ended because you were already involved with someone else, which can affect asset division in some jurisdictions. Third, it introduces a new partner on social media, before your kids are ready, which means that that can be used in your custody proceedings. Courts care about stability and children's emotional well-being. If you're posting couples photos with someone new while your kids are still processing the divorce, that could potentially be made to look like poor parenting judgment. And here's one people don't think about. Screenshots of your public social media posts can be used as evidence of your attitude toward co-parenting. If you're posting vague negative things that could be interpreted as being about your ex, their lawyer can argue that you're creating a hostile co-parenting environment. Passive aggressive posts, even if they don't name anyone, can be brought into court as evidence that you're not operating in good faith. Divorce also involves financial disclosure. You have to disclose your income, assets, expenses, all of it. Social media can reveal when people are lying about their finances. Posts showing expensive purchases that you didn't disclose, check ins at properties you claimed you didn't own, tags at events that cost money you said you didn't have. Lawyers use social media to cross reference financial disclosures, and when they find discrepancies, it destroys your credibility on everything. Some people can't resist posting about their divorce, venting online, sharing their side of the story, posting cryptic posts and quotes about betrayal, or moving on. Every single one of those posts, though, could be used against you. Judges do not like public airing of divorce details. It shows poor judgment, especially when kids are involved. And anything you say publicly about your ex or the case can be brought into court. There are documented cases where judges have sanctioned parties for posting about ongoing divorce proceedings, especially when those posts violated confidential orders or disparaged the other party. Every family law attorney I know gives the same speech. Go dark on social media. Make everything private. Stop posting entirely until the divorce is final. Don't post about dates. Don't post about purchases. Don't post about your feelings. Don't post passive aggressive posts and quotes. Just stop. And if you absolutely must stay on social media, assume your ex's lawyer is screenshotting everything you post because they are. Okay, we've covered personal injury and divorce. So let's talk about something people really don't think about, your fitness apps and location data. Your devices are constantly collecting data about you. Your phone tracks where you go. Your smartwatch monitors your heart rate and activity. Your fitness apps map your runs. All of that data can be subpoenaed and used as evidence. Fitbits and Apple Watches track your heart rate constantly. In assault cases, the data has actually been used as evidence. If someone claims they were attacked, their smartwatch data might show a sudden spike in their heart rate at a specific time, which would corroborate their testimony about when the assault occurred. Conversely, if someone claims that they were attacked but their heart rate data doesn't show any elevation or stress response during the alleged time of the attack, a defense attorney could use that to challenge their story. And here's one that's actually helpful for protecting people: location tracking. If someone has a restraining order against them requiring that they stay a certain distance away from someone, their phone's location data can prove violations. Google Maps tracks everywhere you go if you have location services on. The data can show someone repeatedly going to a place that they're legally prohibited from being. Courts have used phone location data to prove stalking, harassment, and restraining order violations. Ring doorbells are also used as evidence. Ring doorbells and similar home security devices create video evidence of who comes to your door and when. In custody disputes, that footage has been used to prove a parent showed up drunk or didn't show up for scheduled visitation. In neighbor disputes, ring footage is constantly being used as evidence of trespassing, harassment, or property damage. The interesting legal question is, whose footage is it? If my Ring camera captures you on my property, I generally have the right to use that footage. But if my camera is pointed at your property and constantly recording you, that gets into privacy issues. Courts are still working out the boundaries here. Google Timeline is also tracking everything. If you have an Android phone or you use Google Maps, Google keeps a detailed timeline of everywhere you go. It's called Timeline and it's shockingly specific. It knows what time you leave your house, what route you took, how long you stayed at each location, and when you return home. The data can be subpoenaed in legal cases. It's been used in everything from proving someone violated probation terms to showing that someone lied about their whereabouts. Most people have no idea that this feature exists or that it's running by default. And now here's the reality. There's a trade-off between convenience and privacy. All of this tracking makes your life more convenient. Your maps work better, your fitness apps give you better data, your smart home devices make things easier. But the trade off is that you're creating a detailed digital record of your entire life. And that record can be accessed if you're involved in a legal case. You can turn a lot of this tracking off. But most people don't because the conveniences do outweigh the abstract privacy concern until they end up in court. And then they realize that their phone has been creating evidence against them the whole time. My advice, know what your devices are tracking. Go into your settings, look at what location data is being collected, check what health data your apps have access to. You don't necessarily need to turn everything off, but you should at least be aware of what's being recorded. And if you're ever involved in a legal situation, assume that all of that data will be subpoenaed. Your location history, your health data, your text messages, your emails, all of it can be accessed with the right legal process. All right, we've talked about injury claims, divorce, and tracking data. Let me give you the practical breakdown of what you actually need to know. Let's get into the mechanics of how social media actually becomes evidence because understanding the process makes it more real. There are three main ways that lawyers get your social media. Public posts. If your account is public, lawyers can screenshot your posts and use them as evidence. Courts have consistently publicly posted content has no expectation of privacy. Discovery requests. If you're a party to a lawsuit and your account is private, the other side can request your social media content during the discovery phase. You are required to provide it. If you refuse, you can be held in contempt. And then there's subpoenas to the platforms. Lawyers can subpoena Instagram, Facebook, TikTok, and any other platforms directly for your account data. The platforms have legal teams that respond to these requests and turn over posts, messages, metadata. Not everything you post, though, automatically gets into court. Evidence has to be authenticated and relevant. But social media posts are pretty easy to authenticate. The platform can confirm that your post came from your account. If your face is in the photo or you're tagged, that's authentication. Metadata shows timestamps. Screenshots are admissible too, as long as they're properly authenticated, usually meaning someone testifies that they took the screenshot directly from your account and they didn't alter it. And here's why deleting doesn't save you. Deleting a post doesn't make it disappear. First, if someone already screenshotted it, that screenshot is evidence. Second, platforms keep deleted content on their servers for periods of time. Lawyers who move quickly can subpoena deleted posts before they're permanently removed. Third, if you delete posts after a lawsuit is filed, that is considered spoliation of evidence. Courts can sanction you for destroying evidence. In some cases, judges will instruct the juries to assume that deleted content would have been harmful to your case. Every post you create has metadata attached to it: timestamps, location data, device information. The metadata can contradict your claims. If you say you were somewhere in a specific time, but your Instagram's post metadata say that you were somewhere else, that is a problem. Private accounts aren't protected in lawsuits either. Making your Instagram private stops random people from seeing your posts, but it does not protect you from legal discovery. If you're involved in a lawsuit, you will be ordered to provide access to your private accounts. The privacy setting is irrelevant once you're in litigation. And here's what that means practically. If you're involved in any legal situation or you think you might be, make your accounts private immediately. It won't stop discovery, but it will limit who can casually browse your content. Stop posting anything related to the case or anything that could contradict your claims. Go through your post history and identify anything problematic. Don't delete it after the case starts, but at least know what's there so your lawyer isn't blindsided. Tell your friends and family not to tag you or post about you. Assume everything you post will end up in front of a judge or jury. If you wouldn't want it read aloud in court, don't post it. And by the way, that's a good rule of thumb for life. Now it's time for petty court. Today's case, it's someone screenshots your Instagram story and brings it up in an argument 6 months later. Now, this isn't a legal dispute. This is a personal argument where suddenly they pull out their phone and say, "Oh, really? Because in July you posted that you hate brunch, so why are you suggesting brunch now?" They've been holding onto this screenshot for half a year, waiting for the perfect moment. So the question is this valid evidence in a personal disagreement, or is this psychotic behavior? Here's the thing. You did post it. It was public. If you said you hate brunch in July and now you're claiming you've always loved brunch, you're contradicting yourself. The screenshot proves it. But also, who screenshots a casual story to weaponize 6 months later? That is not normal. That's someone building a case file on you, and that's prosecutorial energy, and we don't need that in a friendship. My ruling, the screenshot is technically valid. You posted it publicly, you can't claim it doesn't exist. However, someone who saves your stories for months to use it as ammunition later is revealing something about themselves. They don't let things go. They're keeping score. They view your relationship as adversarial. That's not friendship behavior. That is surveillance. So the verdict, they're factually correct, but emotionally unhinged. You should probably acknowledge that inconsistency. But you should also seriously consider whether you want to be close with someone who screenshots your stories like they're gathering evidence for trial. Court is adjourned. Okay, so here's the bottom line. Your social media is evidence. The location data is evidence. Your fitness tracker is evidence. And deleting things doesn't actually delete them. The legal system has fully adapted to technology. Insurance companies, divorce lawyers, prosecutors, they're all mining your digital life for anything they can use. And you're making it incredibly easy by posting everything publicly. I'm not saying you need to delete all your accounts and disappear, but you should know what you're creating. Every post is a potential exhibit. Every story is a timestamp. Every check-in is proof of where you were. Before you post, ask yourself, would I be okay with a lawyer showing this to a judge? Would I want opposing counsel to have this? Could this contradict any claim I might make in the future? If the answer is no, then don't post it. Thank you for being here. If this episode makes you want to go private on every platform, well, all right. Find me on Instagram at Jasmine Weg ESQ. Follow the podcast at Exhibit A List Pod. Follow me on TikTok at Jazz the Lawyer. Next week, we're back with whatever legal chaos finds us. Stay curious. Please follow the pod, save it, rate it a 5-star, leave a review, leave a comment, and please share it with a friend who loves lawyer energy. Stay curious, friends.